So what this is, if you haven't been on one of our live forums before, these are great. I'm here with Brad Barth, who's one of our expert asset protection, estate planning, and business planning attorneys at Barth Calderon. And these forums, we get asked a ton of questions across the country because we do about 40 to 50 workshops a year everywhere. Brad's one of our top speakers too. A lot of different groups, Vistage International, the California Apartment Association, and just on and on and on. And so we use these forums as a way to give back education, answer questions, and really as a value add to our community, whether it's clients, prospects, whoever we're talking to. So what I've done is we've collected a lot of questions up front. There's live Q&A there. If we're getting into some topics here, you can type your questions. We'll try to get to them right here on the forum. So, Brad, I want to jump right into this. Anything you want to say before we start, Brad?
No, just thank you. I always appreciate people taking the time out to educate themselves in this area. And again, I know everyone's time is valuable, so I do appreciate them taking the time out to spend an hour with us this morning, Paul. Thank you.
Great. Yeah. So here's where I want to start, is that we get asked this a lot. One of the biggest challenges we have is getting people to even do asset protection, right? Because they always think, and Brad, you always mention this, bad things happen to other people. So what I want to start before we get into the specific questions is, Brad, how would you define asset protection? I mean,
Okay,
people,
sure. Well, let's also say that bad things happen to good people.
Right.
So let's start. That's a whole nother discussion. Okay. So I think what's important to realize is that we live in a very litigious country, right? We have a legal system that encourages lawsuits, unlike other legal systems around the world. I'm thinking specifically about the English or the British system, where it's a little bit of a different playing field. We have a legal system that kind of encourages litigation. It's really there to support the little guy against the big guy. Hence, we have things like contingency fee lawyers that are really not even allowed in other types of legal systems. So we have something that encourages it. We have an insurance industry that also encourages it as well. So I think as a general statement of why asset protection is important is simply because all of us, I tell people, everyone wakes up every single morning, they put their pants on one leg at a time, and they go out there and try to make a living for themselves. But all those assets that you work so hard for are always at risk simply because of our legal system. It's a lot of times people can sue you and they have no skin in the game. It's based upon a contingency fee, and you're guilty until proven innocent. And sometimes it's not even about getting to a who's right or who's wrong. Sometimes people just use the legal system as a coercion tool to pull money out of you, or they use it as part of a negotiation tool, when in fact you may have done nothing wrong. And so the whole point is that I look at asset protection not as a how do I structure my assets to protect from the claims of creditors, because of course that's one of its main purposes, but I look at it more as a component to a comprehensive financial plan. And if anyone has ever done financial planning, you've dealt with 5 key areas. And this is a very basic component of any kind of financial planning with a CFP or some investment advisor. You talked about insurance planning, which deals typically with life insurances and disability insurances. There's some risk management stuff. You've dealt with investment planning, modifying your portfolio, diversifying your portfolio, having a balanced portfolio. You've dealt with income tax planning. How do you best maximize your taxes? We all have an obligation to pay taxes, so you can't have tax avoidance, but you have no obligation to pay 1 red cent more than you're legally obligated to pay. So minimizing taxes is part of your overall financial plan. You have retirement planning. Of course, that kind of speaks for itself. And ultimately, you have estate planning. So this is the 5 key areas of a comprehensive financial plan. But every single one of these areas, Paul, deals with sometimes 1% or single digit differentials. If you're going from 36% to 34% in your taxes, or your portfolio is going from earning 6% to 8%, that's a 4% difference. But when you get hit in a lawsuit, you can lose everything. You can lose 30% your net worth, 60% net worth. It can result in your bankruptcy. So I look at asset protection. Not only do we have potential bullseyes on our foreheads just because of the litigation environment that we're in, but also it's part of an overall comprehensive financial plan. It's the sixth element. It's that sixth element of a comprehensive financial plan. Not only do you want to protect and preserve your assets, you want to make sure they're able to withstand credit or attack as well. That's kind of my philosophy about asset protection.
Yeah, it's a great way to put it. One of the components, and so who needs asset protection? Because when we're talking to people, it's like, okay, well, they think it's for the Rockefellers and the Kennedys and so forth. But is it really how would you?
Yeah, I would say that it's really for just about anybody that has assets. And I mean, you don't have to be the Rockefeller, because listen, Paul, if you have a residence, and that residence you've been working on, you've been paying a mortgage down for 20 years, and you built up maybe $300,000, $400,000, $500,000 in equity, at least here in the California area, but in other parts of the country, it could be $200,000, $300,000 is a substantial portion. You paid it down. You got some money tied up in retirement. You got a little bit of money set for savings. Now, it may not be a Rockefeller, but it's everything to you, right? It's everything that you've worked for. It's everything that you're providing for your family. Right? It's your soul, it's your sweat, it's your day in and day out. It's everything that you've worked for. So you don't have to have uber millions of dollars. You could just be an average person. But again, if you had that car accident, if your kid drives the family vehicle, because your dog bites somebody, you have a rental property, now everything that you have is at risk. And it may not be a couple $1 million. It may be $300,000-$400,000. But again, it's everything to you. So who needs it? In my opinion, everyone needs some type of asset protection. Whether it's just an insurance policy, maybe it's a simple family trust, maybe it's a simple LLC here or there. It doesn't have to be complicated. The plan needs to fit the facts and circumstances. But there are people, Paul, that don't need it. And those are people that don't have anything.
Right.
Either the state or federal government through exemption plannings automatically make you basically insolvent. I mean, from an asset protection point of view, because if you can't get anything out of you, then you're collection proof because you have no assets. Right. And sometimes we get phone calls, people saying, hey, I want to protect my assets. I said, no, in your circumstance, go see a bankruptcy counsel because you don't have the assets to put a plan together. So this goes back to what, Paul, you always talk about the assessment, and that's part of it. And so, but that's the long answer. But the short answer, I think, you don't have to be the uber wealthy. It's whatever you have is everything to you, and it's important to protect that.
Yeah, I've heard a story told at our firm by your dad, our founder, about the shoe cobbler at Penn Station who, saved up all his money, bought a house, and wanted asset protection. It was the only thing he had, but to him, it was a really big deal. He didn't want to take any chances.
And I've been doing this for now 21 years. This is my 21st year of doing this type of work, and you come across everything. And one story that always kind of sticks out to me. One case I had dealt with a guy who owned a cigar shop, and and I always think about his savings. Again, it wasn't in the millions of dollars. It was in the several hundreds of thousands. But I always think back to myself and say, how many cigars does this guy have to sell to, after all of his expenses, save up $300,000-$400,000? When your average cigar is $10 a stick. And I always think about that one guy. It's like it may not have been millions, but for this guy, it was 20, 30 years of hustling cigars. It was everything to him. You know what I'm saying? It's
right. Yeah. Great story.
Yeah.
All right. Yeah. Well, let's jump into some of these questions that we got that people sent in. And here's one we get asked a lot is dealing with limited liability companies and choosing the proper jurisdiction. And so we see very easy today to go create your own, click on the internet, a couple $100, you set it up. But one of the most important things I've heard you talk about a lot is choosing the proper jurisdiction. But the question is why? You often say, Brad, Delaware, Alaska, you set that up versus some of these other states. could you get into a little bit of detail of why you would want to use Delaware, Alaska versus some other state?
Sure, sure. Okay, and really what it boils down to, and what you're talking about, a limited liability company is LLCs. And this conversation is also is relevant if you have a limited partnership. Limited partnerships and LLCs are very analogous. So although I'll be talking about LLCs, this also kind of falls sometimes into the Uniform Limited Partnership Act. Now, this does not apply to corporations. So let's make sure we're limited in scope as to what type of entity we're talking about here. So when we're talking about different jurisdictions, you always have the home jurisdiction. So in this case here, we're from California. So we're always going to have our clients registering the entity in California because management, all the decisions are being made here from California. There may be employees here in California. There may be real estate located here in California. So you always have to be conscious of the home jurisdiction. So what happens here is that so although you may be doing business here in California, it doesn't mean that you have to choose your resident state as the state that governs the entity, right? So to use your example, we could have a Delaware entity, but in this case, because the management is happening here in California or it's holding California property, it needs to be registered in California. So you have this multi-jurisdictional LLC. A Delaware LLC registered in California, a Delaware registered in Florida, Delaware registered in Florida and California because of the circumstances. But the question you're asking is why Delaware? And this all boils down to what's called the state's remedies. So once you have this entity and you've chosen the jurisdiction, we choose the jurisdictions because they provide certain limited remedies. That is, what can a creditor do to reach in and grab those assets? And every state, remember, we're a country of 50 states, which means we have 50 variations of the law. So what says here in California, to the extent that a creditor can reach into that LLC and grab the LLC assets, is different than what Nevada says, or what Wyoming says, or what Delaware says, or what South Dakota says, or Alaska says. So we try to pick states that create the biggest barrier, the biggest hurdle for a creditor to be able to reach into the LLC and grab the assets. And every state is different. In this case, it's called a charging order. What charging order remedy is available to the creditor when they're attacking your LLC? And it's different. Every state is different. And so when we're choosing, okay, let's use Delaware, it's because we're trying to present a more difficult challenge for a creditor to get into those assets. Or it could simply just be, I have a client who's doing business and maybe they have an eye on selling the business 5 years or 10 years from now. We want to be able to cast the widest net to potential buyers. And a lot of M&A, that's mergers and acquisitions, brokers and businesses, are very familiar with Delaware laws that are very friendly for business acquisition. So maybe we'll put the business in Delaware. Not only is it a good asset protection jurisdiction, but also casts a good net for mergers and acquisitions. Maybe we'll put some assets inside Nevada, maybe some assets in Wyoming. So we kind of sprinkle it around to kind of, again, diversify the overall asset protection approach, because we want to make it more difficult, more timely, more costly for a creditor to come after your stuff. Just because you happen to be living in California doesn't mean that everything has to be in a California LLC. Mix it up a little bit. Try to pick those jurisdictions that make it more difficult for a creditor to reach in and grab that. And that's what we're relying on. Now, that being said, Paul, I should point out that it does create what's called a conflicts of law challenge. That is, if you have a liability here in California, the ability to enforce a jurisdiction, an LLC, for example, in Nevada or some other states, does create a conflicts of law, which is a little bit of an unsettled issue. So we kind of like having some of that potential confusion, because remember, what we're trying to do is create an environment that's ripe for settlement for our clients. We want to make it as difficult as possible, not only by using protective jurisdictions, but also creating these multi-jurisdictional, these multi-state conflicts of law challenges. So all of this kind of works towards the ultimate goal, which is to get the client to a position of settlement. So that's why we use different jurisdictions. Maybe your home state is great. I have a client that's from Nevada. great, we'll just use Nevada across the board. It's awesome. But when you have states with clients that are not in such advantageous jurisdictions, I'll just use again California, for example, we want to reach out and borrow the state's law for those that are more favorable to give our clients the greatest advantage when and if they need to negotiate a settlement with their creditors.
So if somebody gets sued, so process is, something happens in life, somebody's getting sued, and there's a judgment there.
Right.
What actually happens, Brad? I mean, they get, an attack attorney and they start coming after you, and what actually happens? I mean, they actually reach in and take things, and what does that look like?
Yeah, now that's all a matter of whether they can reach in and take things is all a matter of timing, because when you actually have in this case, a judgment creditor, now it's a matter of timing. Some clients come to us a little too late. It's after the fact or maybe post judgment. Now they want us to move their assets around. There's a remedy. Here in California, we called it a voidable transaction. In other parts of the country, it's called a fraudulent transfer, where you're moving assets around either because of an event already occurred or you're trying to do it after judgment. And in those cases, asset protection it's not as strong as it possibly could be. But to answer your question, what happens is post-judgment, you basically get an order from the court to empower, typically it's the sheriff, to go after and levy, to grab to take the assets and to execute on that judgment. Because during the first phase of litigation, Paul, what you're mentioning is that you're only determining whether or not you're liable for whatever the action is. Whether are you liable for the car accident? Are you liable for the fire as a result of the burn down of the rental property? Are you liable for the dog bite? That's the first phase. It's called the liability phase of litigation. So that's the question. It's not really how much money do you have. The question is, did you run the red light? And that's the liability phase. Once you're found liable, that means you didn't settle out. You went, we went to judgment. Now you're liable. Now the next question is, what assets do you have that we can take away from you? It's in that collection phase, that second phase of the litigation, the collection phase. That's where the asset protection takes place. The question is, now that you have a liability, you have a judgment creditor. How do they get the assets? You go through a debtor's examination. You have stenographers. You have interrogatories. You have depositions to fully disclose what the assets are, how they're held, how they got in there. So there's no hiding what happened. It's fully disclosed, timing, everything else. And that's when they start levying, they start grabbing the assets and foreclosing on the assets, having judicial foreclosure of the assets. And this is where our structures make it more difficult, because you're back at the liability phase. You have to go collect the assets. And again, if the assets are local, then it's a lot easier. But if we've used a mix of multiple entities that have some protective structures, and then we further mix that up in different jurisdictions, the collection phase becomes more challenging, more difficult. And that's where the asset protection really kicks in. It's not on the liability phase. It's in the collection phase. And some attorneys, plaintiff's attorneys, looking forward saying, hey, if I win the lawsuit, I have to deal with this collection stuff, because some of this stuff does get disclosed in the course of discovery. Some of the stuff does get disclosed as a means of settlement negotiations between the parties. They let them know what's actually going on here. And so ultimately, when they realize that they're going to have to deal with this at the end of the transaction, hopefully they're encouraged to work with their client to enter into a faster and favorable settlement. We're trying to settle out in the liability phase before it gets to the collection phase. But that hopefully answers your question.
Yeah, no, it does. And I just to expand on that. So let's say you have a LLC around an investment property, right, and someone's coming to collect. Do they start trying to pick apart your LLC? Do they start trying to find holes like in the operating agreement or the jurisdictions? Is that what happens?
Yeah, of course. I mean, think about it. You're always, and part of our job as the asset protection attorneys is to try to anticipate some of those things. And this is where we would look at a client's existing operating agreement for an LLC, or look at the transactions or the transfers, the paperwork, to try to see, well, if I was trying to attack this, where are the weaknesses, and therefore what should we patch up? So yeah, absolutely. The entire, not just the individual documentation, but the entire transaction. And sometimes it can be very, very subtle, right? There could be something buried in clause, 11.1.3 that allows them to kind of come in because you have a certain retained power. So it gets very subtle. And I always say that, unfortunately, the clients never truly appreciate all that we go through, to try to help them out, because there's subtleties. And, but yeah, they look at everything, right? They think about it. You as a plaintiff's lawyer, you've invested a couple $100,000 or more in litigation coming after somebody. Now you need to collect. Now you bet you're going to try to find any way to recollect your investment so you can get your 30 or 40% contingency fee and reimburse your own out-of-pocket expenses. After all, you're funding somebody else's litigation. Right. So of course, anything they can use. We call it, they even kitchen sink it and to see what sticks. So yeah, I mean, they get very creative, but that's how it works. That's the world we live in.
Yeah, and that's why, like, in the workshops you deliver, I mean, I know it comes up a lot where if you have crappy planning, whether it's an LLC or whatever you're doing, and nothing ever happens to you, okay, then it's almost like who cares? You don't need it. It's like earthquake insurance on your house. If the earthquake never comes and you didn't pay your premium,
right?
Yeah, it's when something happens, right? Is when they, yeah.
That's when the rubber meets the road. That's right.
Yeah. Okay. Let me jump into got about a lot of questions here. Okay. So you answered that on why using specific states. So the maintenance of the LLC. Here's someone asking us, okay, I set up my LLCs. I've got 3 of them. Is the maintenance an important part of having the LLC? So they're asking about, maintenance and making sure that's right.
Sure. Okay. So just like anything, you need to maintain the integrity of the structure. And so, Paul, you're right that not only up front do you have legal costs to get these structures set up, but then if we're registering these things, we'll go back to our Delaware, California example. Okay, you gotta pay Delaware $350 a year to maintain the entity status, so the entity is still in good standing. You got to pay California, in our case, $800 a year. We're one of the most expensive states in the country. So now you're already out $1,200 just right there. You have to have what's called an agent of service or process, so somebody in Delaware to represent the company there. So that's probably another $115, $120. So you're looking at now about $1,350 a year to maintain the structure. So there comes now a cost benefit. If you're not in California, then of course it's going to be much, much cheaper. And I do speak around the country, and I know that a lot of places, $50 a year, that's all there is to it. So maybe it's $100 or whatever. So it's much cheaper. But to your point, once you set it up, you have to maintain that. Just like anything else, if you got to keep the integrity in good standing. And to your point about 3 different entities, some clients they get overwhelmed with the amount of compliance necessary to kind of keep this in place. And normally when someone comes to me, it's very rare they're going to walk away with just one LLC. In one jurisdiction. Most likely it's going to be 2 or 3 LLCs in multiple jurisdictions. I already gave you a handful of examples of the Wyomings, the South Dakotas, the Delawares, and Nevadas. And so you're going to have a lot of expenses. And some clients, it becomes an overwhelming task for them. So our office does provide an additional service. We call it EMS, which stands for Entity Maintenance Services. And we help to alleviate some of that annual administration. And so rather than the clients having to deal with all of those ongoing administrative costs and expenses and mailings and reportings, we take that burden upon ourselves. And we go ahead and do things for them. And that's very important, Paul, because if at the time the entity is sued, it's not in good standing, it's suspended or maybe it was foreclosed, then you yourself are living under a false sense of security that you have this entity in place to help limit your liability or to protect your asset when in fact it's not there. Why? Because you forgot to file some form. or you forgot to pay some fee. So, so it's important that these things be maintained. Just like anything, you got to maintain it. You got to maintain your personal finances. You got to maintain your house. You got to maintain your car in order for these things to work correctly. And you got to maintain your structure.
Right.
So we actually, for those clients that are interested in that type of work, we do have a website. It's called barthagencyservices.com, BARTH, barthagencyservices.com, and on there it's a splash page which kind of explains what our office offers for this EMS, this entity maintenance services. You don't have to be a Barth client already to take advantage of that. We have many clients that have already pre-existing structures that we help them maintain that, again, just to relieve them of the burden of having to deal with that. And it's all kind of explained on the website. But yeah, maintaining the structure is vitally important.
Well, Brett, I wanted to ask you about online businesses, because we're working with a lot of Amazon sellers across the country, and this has been an incredible area for us. We're kind of the top firm helping Amazon sellers, and it's like the Wild West with those Amazon sellers. It's crazy. They started their business with $100 in their garage. They're doing $1.5 million a month,
Exactly.
and so yeah, and you're working with most of those folks, and so a lot of the younger entrepreneurs, business owners that we encounter, whether it's Amazon or somebody else, and there's a lot of them today. People are killing it in business in a lot of different ways. We get input from them a lot that they don't really understand why asset protection would apply to them running an online business. They're young, they're feeling invincible, but an online business, aren't there similarities to any other business when it comes to protecting yourself, but are there specific issues with the online business, and what do those folks have to watch out for, and what do they need to do with their business?
Okay, great. So first of all, I'll just start with a generic statement that there really isn't any difference liability-wise from a brick and mortar shop from an online shop. You're still dealing with the public. You're still putting a product into the stream of commerce from a liability point of view. You're still part of the chain of distribution that ultimately, if you're selling vitamins, you're selling electronics. Let's take an electronics. Right? I buy stuff on Amazon all the time for my smartphone and my computers, and I buy portable chargers. And what if I buy a portable charger on Amazon from some vendor I have no idea who it is, and I plug it in, it burns my house down? You bet your butt I'm going to go back and sue that guy, right? Because he sold me a defective product. And so now he may have to turn that over to whomever the manufacturer is, but that's not my problem. That's his problem, right? I'm suing the person that I dealt with. So whether I walked into Best Buy and did it, or whether I purchased it from an online service, the liability for the products they put in the stream of commerce is the same. Now, many of these people have employees. I got plenty of clients, Amazon specifically, that have 20, 30, 50 employees because they themselves are either they're putting things together, they're manufacturing, they have their own warehouse, they got their own fulfillment going on. So they have employees and all the issues associated with employees. That doesn't go away, right? You have lease obligations, contract obligations, products, stream of commerce issues. And then like you said, we have a lot of clients that are being very, very successful. Now they're accumulating individual assets, whether it's houses, it's brokerage accounts. Now they have personal assets they want to be protect against. Again, spouse, kids, friends, neighbors, rental properties, products, stream of commerce coming up to them. So I don't see any difference, Paul, between brick and mortar and online. As a matter of fact, I think the online stuff is a bit more complicated. And we know last year there was this big Supreme Court case that came out, was called the Wayfair decision, that dealt a lot with sales tax. And the sales tax has been a real problem for these online people. I got a guy who lives in Arkansas, and the next thing you know, Amazon decides to sell something through Washington State, which gets distributed through California. And this guy in California is harassing the Arkansas guy for sales tax. And I was like, what are you talking about? I never stepped into California, but the FTB here in California is coming after him for past sales tax. They have no control over those issues. And that's still, although we had the Supreme Court decision in Wayfair, how the states are going to deal with it, either going forward or even retroactively, is still unclear. We're still working with that. So I would think that online businesses have even higher liability because of that uncontrolled uncontrolled jurisdictional issues, sales tax issues, whereas a guy that has a physical address in Arkansas, well, he's going to pay Arkansas sales tax. That's pretty clear, right?
So how would that work if I'm selling online, and whether it's supplements, I take a supplement, I get sick and whatever, or the electronic component, and people sue, that happens. So they sue that seller on Amazon. How does that reach that person's personal assets, their home, their stocks, bonds, and cash? I mean, don't they have insurance to cover that?
Well, sure, you can have insurance, but you have the insurance issue is always interesting, because insurance is, first of all, they're limited. I would say insurance is limited in time and scope. It's limited insofar as you actually have coverage. So if you're covered or you're not covered, so that's one thing. Or what if the policy lapses, or I forgot to make my premium payment? So you have to worry about timing issues. It's limited in scope, because some people have a commercial liability policy, but it didn't cover a product defect, or you were selling a product that wasn't part of the coverage of the insurance, right? You branched off in a way that wasn't part of your original coverage, so you had an exclusion. So insurance is great, Paul, and I recommend everybody have it, but by no means is it a asset protection plan. And just one last point is, if you have a liability that exceeds the insurance coverages, now you have a deficiency of coverage, you still own that also. So insurance is fine. So you got to have it, but I wouldn't rely on it. It's just something that you want to have to mitigate some of the damages. But so if you're back to the question you're asking about personal versus corporate, here again, if someone sues you and you have an online presence and it's not incorporated, because I got many clients say, I'm just doing a DBA, man. I just kind of set this up. It's my account. I decided to sell something one day and I got a DBA, whatever it is, Scanners R Us or whatever it may be. And as a result, you have unlimited liability because you are the seller individually. If you happen to set up a company, Scanners R Us Inc. or Scanners R Us LLC, and then you're selling it through the entity, now at least you have one layer of additional protection. If the insurance fails you, you now have some limited liability by the entity. And that's why everybody sets up corporations or LLCs or some type of a limited liability entity to do businesses. Here again, I see no difference between a brick and mortar shop and an online shop, for not only for the exposure and the asset protection, in general, right? Right.
Well, interesting. Carrying that thought on the online sellers is that, so if they have a corporation, online sellers got a corporation, and we're seeing a lot of them that are doing really well. I mean, multi-million-dollar businesses. They have their Amazon business as a corporation, and they have a liability. Let's say they have a business partner or a spouse, or they have a rental property separate from the business, and there's liability going on with those other people. They have a car accident, or there's a tenant that sues them in the rental property, and all of a sudden they have this liability, nothing to do with the business,
right?
But it can come over and attack the business, their stock, isn't that right?
Yeah, that's right. Yeah, because this is where one of the big, and as I think when I was answering the question earlier about LLCs, where I said that this deals with LLCs and limited partnerships, it's not corporations. The question that you're asking now deals with corporations and not LLCs and limited partnerships. Because as we already explained, that in LLC land and limited partnership land, we have what's called the charging order remedy, which helps to mitigate some of those outside grabs I was telling you about. But when it comes to corporations, it's different. Corporations are, you actually, as the business owner, you own stock, okay, stock. And that stock is basically personal property. And it, just like when someone comes after you, and again, to use your example, Paul, if you have a business partner and the business partner is broke, they're going to come after the deep pockets, right? We call this the joint several liability rule, right? And if you happen to be the deep pockets, one of the assets they're going to want to grab from you may be your stock. If you're married, it could be a joint liability, or in states like mine here in California, community property land, it could be a community asset, a community liability, which means they can grab my stock. Can't do this in LLC land and limited partnership land, but in corporations land, they can grab the stock. And if you grab the stock, that stock represents ownership, it represents control, represents access to books and records. And so what happens is that we call it a turnover order. Just like a creditor from the outside is able to grab your house, they can grab your brokerage account, they can grab your retirement assets in some examples, they can grab your 529 plans, they can grab your stock. And if they grab the stock to the company, regardless of what the liability source is, whether it's you, a partner, a spouse, a kid, a rental, whatever, if you have a liability, they can grab your stock. And then that stock, they now become the owner of the company. They may not want to run your Amazon store. They may not want to run your brick and mortar store, but you do, right? And as a result of that, they can use that as leverage to your disadvantage in negotiating a settlement. Again, this is one of those, like, I call them pain points, right? There's certain things that you can push that basically make people scream uncle. And as a result of that, the whole point of getting into a fast and favorable settlement goes away because they got you. And grabbing someone's company is one of those types of assets. So we do have tools where we can fix that problem, but that's something that's definitely a concern to have. Corporations are a little bit unique, and we have better alternative vehicles to run your business on. Right.
And it's amazing. And this actually happens. I mean, creditors take control of stock all across the country every day. I mean, I always ask that question, really, Brad? Does it really happen?
Yep. No, we've seen it. We've done it in our office, and we've defended it in our office. So it's not every state. Now, again, one of the benefits of being a national speaker is I get to research these areas. I go from state to state, and not every state allows for what we call this reverse piercing rule. Not every state allows it. Some states, the Supreme Court has just said that, no, this ain't happening. But I can tell you that there are, I think, just half the states do allow for it, right? It is a viable remedy. And even still, even if it's not a viable remedy, this plaintiff's attorney is getting back to your point on, do they actually attack this stuff? The answer is yes. And if they still threaten you with it, again, that's a pain point. It makes you scream uncle. And they've won that negotiating round because they're threatening you with your business. And that's a big deal. And so we want to make sure we take that option away from them. And again, we have tools to do that.
Yeah, and it seems like your comment earlier about the asset protection as a component of a big picture planning is so key, because with the successful entrepreneurs, if you're running a successful business, you're doing A, B, C, D, E, F, right? You're making sure you're buttoned up, and so often the asset protection piece is left out, but it needs to be in there. And it's just, a successful business owner will include asset protection as part of the template.
It's just the realities of us, of our political and our judicial system. It's just the way that it goes. Yeah.
Right. Well, someone's asking here, I'm just checking the time. So Luke Perry passed away recently. And it's funny because my wife and I used to watch that Beverly Hills 90210 when we were a bit younger. And it was a sad story. I mean, the guy was young, and you saw the story, but the guy died young, part of a blended family. Yep. So, the question centers around, people asking about that, about it. From what I read, he had some estate planning. So I think he had a will and a trust. He had a blended family, kids from a previous marriage. He was engaged to be married, not married yet, had assets, died unexpectedly, was in the hospital for 4 or 5 days, then they pulled the plug on him. Brad, so it seemed that went fairly smoothly because he had some documents in place. Mm-hmm. What did he have in place to make that go smoothly, and how could have that gone the other way?
Okay, I'm not familiar with the case. I don't keep up with the celebrity newses. I don't. So actually, Paul, I apologize. I don't know who Luke Perry even is.
Well, so he had an advanced medical directive, so it allowed him to kind of get through that.
Answer that question. Okay.
Yeah. Sorry. You're revealing your lack of Hollywood knowledge, Brad.
I do. I do live in a hole. I admit that, and even my wife complains. You need to get out more often. Okay. Okay. So to the point We'll just focus in on the advanced directive as far as maybe the pull the plug provision. You want to focus it just on that part of it, or also the blended family question?
Yeah, well, it was kind of like just the importance of the planning when, life deals you an unforeseen event, like, an illness, or, in this case, he passed away. But if you don't have planning versus having the right things in place.
Okay. Fine. We'll call this the good, the bad, and the ugly, right? That's
Yeah.
okay. Yeah, and again, getting back to the again, having seen a lot of this stuff over the years. Again, as I mentioned already, I've been doing this for 21 years, and it's not just the asset protection. I got my start in the estate planning area. It's kind of how I started my career back in 1997, and in not only in doing plan design, but also in litigation and administration of the estates. And that's kind of what you're talking about. It's one thing when you're meeting with the lawyer, and it's very cerebral, what happens, who makes decisions for you under these circumstances? My brother, my sister, whatever. But when something happens, and in this case, you had an individual that became permanently incapacitated, whether they were in a persistent vegetative state or they were in an irreversible coma, the documents now make all the difference in the world. And we'll just use the pull the plug example, because you can compare this to the the landmark case about 20 years ago, the Terry Schiavo situation that took place in Florida about 20 or so years ago. And that was an example where someone didn't have any clear and convincing evidence as to what they would want to have happen to them under these same scenarios. So here you had your individual, the actor, basically saying that under these circumstances, pull the plug. And he empowered people through that advanced directive, or in some states it's called a living will. Don't confuse it with a last will. It's a living will, saying under these narrow circumstances, I'm letting you know now, while I have capacity today, I'm letting you know now that if I'm under these circumstances, I want you, my agent, to pull the plug. So you need to say that while you have capacity, and don't confuse it with the DNR. It's totally different. This is not physician-assisted suicide, totally different scenarios. And so under those circumstances, it helps a couple of areas. One, it helps the financial burdens of maintaining someone's life where there really isn't any, let's say, prognosis of recovery. It certainly helps with the emotional expense as well. So you got financial expenses, you got the emotional expense of seeing a loved one in these ongoing circumstances where they're just plugged in the machines, and but for the medical intervention, their body would naturally pass away. And so those are, and not to mention the pure cathartic way of saying that if you are to remove those medical interventions, it's not that somebody can come back to you. And I've seen this in my office where siblings fight saying, oh, you killed mom, you removed her tubes or whatever, you pulled the plug, you killed her. And then listen, the answer is no, I didn't. I only affected what she asked us to do when she had the capacity to make said decision. Okay, so there's a very cathartic effect of when someone who actually has to do that to a loved one, that they know in the back of their mind that they're actually fulfilling the desires of their loved one as opposed to pulling the plug, right?
Yeah.
Very different on how things occurred, like with the Terry Schiavo case, where you did not have clear and convincing evidence. In other words, a writing, an advanced directive, a living will. When you don't have that, now you have fighting going on, right? Not only who does it, but you have conflicts. Like in the Terry Schiavo scenario, you had a husband who's saying, listen, I know my wife, she didn't want to be in this situation, pull the plug, pull the plug, pull the plug. And you got the parents saying, no, we're going to wait for a miracle. No. And you had two interested parties with conflicting positions. And the state of Florida itself really couldn't get involved in that. And so this just kind of dragged on with the media circus. Who knows what the expense was? Forget about the emotional expense. All the way up to the Florida Supreme Court. And I forget how many years this went on for, but it went on for a long, long time. And that could have been completely mitigated had Terry herself simply just said, under these narrow circumstances, this is what I want to have happen, right? And it would have made things a lot easier. And there are some variations in that. It doesn't just mean that you pull the plug immediately. You can put some various stages in there to make it happen. So that's one solution. And especially if you have a blended family scenario, you're always concerned about what the trickle down effects are of the assets. Now, whether this particular celebrity had separate, kind of a mix of separate property and different marriages and relationships and premaritals and postmaritals, none of this of which I know, but sometimes it ties into the pull the plug stuff. Like, you pulled the plug because you want to get paid. It was
right.
greed focused as opposed to true love and affection focus, right? Because you're kind of getting that the dynamics of the family members, and especially if the parents choose somebody as an agent that's not, let's say, the natural bounty. They're biological kids. Let's say, for example, I mean, it's very possible. I got many clients who actually love their in-laws more than their own kids, right? Love my daughter, really love my son-in-law, right? And sometimes they'll actually choose the son-in-law to make those types of decisions and not the daughter, for example. Right. And so you want to make sure that you have that clearly written out, so it doesn't cause what do you call it, fighting amongst the family members,
right.
Who you chose to make those decisions for you, because you would think the daughter would step in and say, "Hey, should have been me. You're my parent." But you want to make sure that you have an active voice in that decision making.
Yeah, Brad, we're hitting up against our time frame. Fantastic input. Really appreciate you jumping on again. And for all those listening, thank you for taking the time. We know everybody's busy, and I always make this this offer that if there's any questions at all, we couldn't get to everything, and there was a couple questions we received beforehand and during that are a little bit out of the scope of this discussion here. But we'll reply to you offline. So look for an email with some of those questions, and then also an offer. You can click on the button when you get the email if you want to talk to us and dive deeper into anything. Always happy to do that. Brad, thanks. We'll see you next time.
Great. Thanks, Paul. Appreciate it. Thanks, everybody. Bye-bye.
Okay.